Mike, I know you're a 13-year veteran police officer, and you've retired. Now you're a criminal defense lawyer, and you're an expert in auto theft laws in California. Let me ask you, what are the laws with regard to stealing a car, breaking into a car? What sort of crimes can you be charged with?
Generally, we'll see three types of crimes people will be charged with in California. First, you can be charged with grand theft auto, which is 487 of the Penal Code, or you can be charged with 10851 of the Vehicle Code, which is stealing a vehicle, or you can be charged with joyriding, a violation of 499B of the Vehicle Code. There's subtle differences in all three of those charges. For example, joyriding is a misdemeanor, and normally that involves the temporary taking of a vehicle, normally by a relative or someone you know. 10851 of the Vehicle Code is a felony, is a wobbler, can be a misdemeanor, and that's either a temporary or permanently taking of a vehicle from the owner. And grand theft auto is a specific intent crime involving trying to permanently deprive the owner of a vehicle.
Now, what about auto burglary? We hear about that a lot. How does that factor in?
Well,
what is that?
Well, auto burglary is, a perfect example is, and we see this all the time, let's say you have a lock secure vehicle and someone goes up and breaks the window, goes inside and takes property out of the car, whether it's a CD, a DVD, money that might be in the console, things of that nature. Auto burglary is basically forcibly entering into a vehicle and stealing something, is probably the simplest way to put it. It could be a felony in California, or also could be a misdemeanor. It's one of those crimes that can be charged, what we call a wobbler.
So it's not really trying to steal the car itself, but it's breaking in to steal something inside the car.
That's correct.
Now, let's say you have a client, and I'm sure you get calls all the time from someone who was arrested in a stolen car. They were driving a stolen car around town. Is that the end of the story? I mean, is there a defense in those types of cases? Are there things that you can do to try to fight the case?
Sure, and it greatly depends on the facts of the case. We had a case, for example, where we had a client in San Bernardino. He was pulled over about 3 o'clock in the morning. In fact, actually, he was contacted around 3 o'clock in the morning. He was in his car along with 3 or 4 friends. He had just bought the car a few days earlier. Cops run the plates, they check it with the VIN number, the vehicle identification number, and it comes back stolen from Riverside County. Our client's arrested. The cops never look at his paperwork, right? And it was a car that came back in the system, stolen. They contacted the owner of the car, said he was arrested, his car was placed in the impound lot, and that's where it should be. So our client, the DA, filed the case, and we get hired. Well, we do an investigation pretty quickly, and we find out that the storage place held it for over 30 days. They lien sold the car to our client, and they never reported the documentation to DMV. That case, we made one appearance, we got that information, we got the information from DMV then, we gave it to the DA, case was dismissed, and actually later on, we did a motion for factual innocence to wipe away any record of that arrest of our client, and that was granted by the court. I'm Mike Scafiddi, a retired police officer, and now a criminal defense attorney with Shouse Law Group. If you or a loved one are in trouble and need help, call me.